afternoon, everyone. Welcome to the Community and Development Program hosted by Carlton Fields Development Industry Group. My name is Jen Liu. I'm a real estate and finance shareholder attorney at Carlton Fields. I'm also chair of our Development Industry Group. Carlton Fields Development Industry Group consists of attorneys and government consultants who work collaboratively and offer efficient, effective, and holistic counseling to developers, builders, contractors, architects, engineers, investors, and other industry constituents, locally, regionally, nationally, and internationally, in the development and investment of a full spectrum of asset classes. And we launched the development and community series back in 2018 to curate an experience in a community in which sound and innovative development ideas can spark, development enthusiasts can convene, and development challenges can be tackled. Since then, we have successfully hosted a number of programs covering topics from mayoral candidates debate on development issues to the baseball stadium, from development and financing issues involving the cannabis industry to the Surfside Champlain Tower collapse, and so much more. Today, we gather here to discuss Florida Statutes sections 692.201 through 205, which were formerly known as SB 264, which was enacted by the Florida legislature and signed by the Florida governor this month. This law essentially bans direct and indirect ownership of certain real estate in Florida by certain foreign principals of 7 countries, with a heightened penalty and stricter restrictions against China. As written, this law will have a sweeping impact on both direct real estate transactions in Florida, as well as indirect equity and debt structures and beyond. So here with me are my 4 co-panelists. Bill Scalar. Bill is practice group leader of Carlton Fields Government Lobbying and Regulatory Practice and managing shareholder of our Tallahassee office. Bill has practiced real estate law for over 43 years and is board certified in both real estate law and condominium and planned development law by the Florida Bar. Bill is also an adjunct professor for over 40 years at the University of Miami in its graduate law LLM program in real property development, and is a fellow and secretary of the American College of Real Estate Lawyers. Next up is Rob Freeman. Rob has been practicing for more than 32 years, and he co-chairs the Carlton Fields Real Estate and Commercial Finance Practice Group. His practice primarily pertains to condominium and community development, but he has been involved in virtually all aspects of real estate practice over the years. Next is Aaron Dunlap. Aaron is a shareholder in our Tallahassee office and Florida Bar board certified in city, county, and local government law. His practice is primarily focused on real estate development, land use, and zoning, developer-oriented issues concerning large-scale community developments, and developer-side homeowners and condominium association issues. He's currently co-vice chair of the Governmental Incentive Group under the REPT section of the ABA, and outreach chair of the Florida Bar's Government Advocacy Committee. And last but not the least, Carrie Hebrank. Carrie is a registered lobbyist and represents a wide range of clients before the Florida legislature and the executive branch, with a focus on construction, regulatory licensing, and permitting, housing, title insurance, building materials, building codes, sustainability, mitigation, energy financing, mining, infrastructure, and utility issues. So before we kick off the substantive part of today's program, I want to make a housekeeping announcement. This webinar is being recorded for educational and training purposes. The recording may include questions and poll responses provided to you during the webinar. This recording will be made available after the conclusion of the live event and posted on Carlton Fields website. Also, if you have any questions, please put them in the Q&A box instead of the chat box, because that will help us to better track your questions. Now, without further ado, I'm turning it over to Bill.
Thank you, Jen, for that introduction and your highlights of the importance of this law. And that's what I want to present today before we get into the details of application of the law and its requirements. I always ask the question when I attend a seminar or any presentation, is this worthwhile? Is this important? Is this relevant to me? I want to emphasize, extremely emphasize, that this law is much more than getting another closing document, such as an affidavit, to be prescribed as part of a transaction. The very broad definitions, which I'm going to highlight, and Jin Liu and others are going to detail, indicate how far-reaching this law is. Now, no one's suggesting the sky is falling. We've lived through FERPTA for 40 years. We've lived through the OFAC laws, and before then, between 9/11 and OFAC, the Treasury lists and regulations. From a corporate standpoint, we've lived through CFIUS, and we will get through this. But in the meantime, we have a highly politicized statute signed by Governor DeSantis on May 8th, clearly sending a message and as part of his imminent presidential campaign. What is going on here is a restriction on purchase and ownership, and just as importantly, reporting requirements in circumstances where privacy, such as private equity companies, such as investment companies, have done business on that basis as long as they have existed. And this goes directly opposite those secrecy, privacy, legitimately type of requirements that occurs in private placement, in accredited investor. And let me give a few examples how broad-reaching. You're going to hear from Jin and others about the 7 nations covered, and in particular, citizens and domiciliaries of China. And we're going to talk about that. But if we look at the definition of foreign principal, first of all, it says that they may not directly or indirectly own or have a controlling interest or acquire, purchase, grant, etc., real property in the state of Florida. But a foreign principal not only includes the governments that we identify, the statute identifies, political party members in control of those governments, but it also indicates that it applies to citizens or domiciliaries of those nations involved. So theoretically, we're not only talking about a domiciliary of Hong Kong buying a piece of real estate. We could be talking about someone from Venezuela. We know, and you'll hear a bit about the fact that we have a very strong Fair Housing Act, which has protected classes, including national origin, which does not allow the conditioning of providing housing to any person on the basis of national origin. This really tests that from the standpoint of presenting issues in the housing industry to providers of housing for those that present themselves, and it becomes a question of how far one can go. So we have this concept of foreign principal, and let me give you some examples. We could have, as typical, a public entity whose board of directors, New York Stock Exchange, NASDAQ, or otherwise, board of directors, senior officers, investment committee, all U.S. citizens, they are making the major investment decisions as defined by their constituent documents, operating agreements, bylaws, articles of incorporation, as the case may be. But upstream, there are investors. There are investors from various countries, and they may include some of the countries on the list, or even one of the countries on the list. The question becomes, does this act apply in that scenario? We believe that as written, it does apply. And you can have an investment entity, which is not necessarily US based, where you will have citizens or domiciliaries of these other entities. They do not have to be members of the Communist Party. That is just one statement in there, as will be detailed in this presentation. And through their ownership, there may be the requirement for reporting, disclosure, and registration, which we'll also detail. So one say, who cares? It takes effect July 1, reporting starts on or about January 1, 2024. We need to care because of the penalties, the severity of the penalties involved. They include felony criminal penalties, $1,000 per day for non-registration and various other violations. And they include, in instances, forfeiture of property conducted on an ex parte basis by the Department of Agriculture relative to lands. So we need to understand this. Well, I've had the question, well, there are de minimis protections. What if the investors have less than 5%? Well, is that enough? The way this is written, that may not apply and may not be enough. And one can easily have more than 5%. But I don't want anyone to fall into the, if you will, the slumber of, or the comfort zone. We're dealing with a US entity. We're dealing with a REIT. We're dealing with a publicly traded entity. The fact that there can be, at different levels, ownership by domiciliaries of any of the nations involved squarely puts all the entities involved at risk. So what we want to do is create an awareness today, create an awareness of what the triggers are. I briefly mentioned and will reiterate what the penalties are. The implementation is yet to occur. And my colleague Aaron Dunlap in a few minutes will be talking about the required rulemaking by any of the 4 agencies of Florida government given jurisdiction over different aspects of that. So I want you to be aware that this does have far-reaching implications beyond just another closing document, an affidavit. It has far-reaching implications as far as the closing agent, who, if they have willful and knowledge of a violation, they can be liable under this act. This may go to also the question of what the liability of a title agent is and how it affects a title to property because of the forfeiture possibility and other effects, lien effects and other effects on title. So there are many aspects of that. And what I'd like to do is ask Jin to cover an overview of some of the aspects of coverage and how this potentially applies. And we'll go from there. Jin?
All right, thank you, Bill. So I actually have prepared some slides. So if Angie or Emily can put that up. Before I start those slides, but as another reminder, if you have a question, please kindly put in the Q&A, not in the chat, because that will help us better track the questions that have come in. So I wanted to talk specifically about some of the details of the law. But before I start, the first slide is also to highlight that even though the law in this case has been signed into law in Florida, but we also have to be mindful that many other states are considering similar law. To our knowledge, at least another 11 additional states are going through legislative process with similar or other one or two aspects of Florida law or different aspects of the Florida law. So let's also pay attention to those. If you have any questions, please put in the Q&A, not put in the chat. With my slides, the first one is to highlight for you all that in addition to this law being in Florida, similar elements of a similar law are also being considered in other states. If you want to find an aggregate place that is tracking the law or similar laws, I have found that the National Agricultural Law Center to be a good place to use because at the center of the premises of this law, at least one aspect of the law, is the concern of food security in this country. Therefore, a lot of the states who are considering this law, including Florida, who has, of course, adopted the law, has an angle of the law in agricultural protection. So the Agricultural Law Center has a tracking on that. If you have any interest, you can follow up on that. Can we go to the next slide, please? So what are some of the key elements of the law? Bill has touched on some of those already, but let me highlight some of them. So in Florida, the law basically has two big categories. And the first category applies to 7 countries of concern. And the second category applies to China only. Under the first category, the 7 countries of concern, who are they? They are People's Republic of China, the Russian Federation, the Islamic Republic of Iran, the Democratic People's Republic of Korea, the Republic of Cuba, the Venezuelan regime of Nicolas Maduro, or the Syrian Arab Republic. So those are the 7 countries. And what does the restriction under this first category apply to? It's a restriction based on 2 big classes. The first one is based on the type of real estate, which is ownership of agricultural land is prohibited. So again, that goes to the center theme of this piece of legislation, which is protect food security. But the second category that applies to those 7 countries is based on location. The thinking behind that is essentially that they wanted to protect property that is within close proximity to a military installation or a critical infrastructure to be purchased by foreign enemy nations. So that's the second category, which specifically says essentially no ownership on or within 10 miles of a military installation or critical infrastructure facility will be allowed. But we have to note that the critical infrastructure definition is pretty broad. It includes any airport, seaport, water treatment facility, wastewater treatment facility, refinery, and the list goes on. So one of the challenges, as we later will discuss with the enforcement of the law, is to determine where are those locations of those infrastructure facilities and military installations, so we know where does that 10-mile radius look like. So let's go to the next slide. The second big category under the law, as I mentioned, solely applies to China, even though China is already within the first 7 countries. And then this second category is a much broader ban in that it's banning of ownership regardless of its distance to a military installation or a critical infrastructure, and regardless of the property type. So essentially, under this particular category, any type of real estate is prohibited to be owned by related parties to China, which we will specifically describe the verbiage from the statute, whether the land is agricultural or not, whether it is close to a military installation or not. So what are the specific targets or subjected parties that are prohibited from owning under this category relating to China? It is, first one, People's Republic of China, which is the country, or the Chinese Communist Party, CCP, or any official or member of the PRC or the CCP, indeed, as one of the examples of understanding the definitions under this statute, it is hard to conceive what is a member of the PRC. So you would have to naturally draw the conclusion, perhaps member of the PRC means any citizen of the PRC, but we don't know for sure. The second prohibited a class of people from relating to China is any other political party or member of a political party or its subsidiary in PRC. The third one is any form of entity or organization organized or having its principal place of business in China. And indeed, under this category, it also extends to any subsidiaries of those organizations or companies. The fourth one is any person who is domiciled in China, but not a US citizen or permanent resident. So again, as Bill mentioned, the definition of domicile here is also undefined in the statute. So some of the questions that have been raised so far include, if a British citizen, for example, lives in China permanently for job purposes, as an expat or otherwise, and if they want to invest in real estate in Florida, now does the statute sweep him in, therefore he cannot buy directly or indirectly? So that's one of the questions. And the fifth category is any companies or entities controlled by any of the above four categories. So those are the targeted companies or people who cannot buy from China. So let's go to the next slide. What are the specific penalties? Bill already mentioned this, but I wanted to highlight that. So $1,000 per day fine for failure to report or register, because as Aaron will later highlight and go into detail on, is that the statute does impose strict and timely requirements for registration of ownership. And so if somebody fails to do that on the deadline, by the deadline, then there is $1,000 per day fine. And then what is also pretty significant of a penalty is that for violation of this law, the state of Florida can institute process to forfeit the ownership of the real estate. And as we know that private ownership in Florida, as well as the rest of the country, is pretty well respected. So to have a forfeiture nature of the law is a really significant and impactful penalty, and we have to be careful. And because of this, later on, I will be speaking to the fact that the forfeiture aspect particularly will also raise alarm to our lending clients to make sure that they understand the potential consequence of violating the law. And then the third one is different types of criminal penalties. In my prior discussion, I already highlighted the differences between the first category of the law dealing with 7 countries and the second category dealing with China alone. But in this criminal penalty category, there are also pretty significant differences between those two categories. Essentially, for a foreign principal to have violated the first category that applies to 7 countries, the criminal penalty is misdemeanor of second degree. But to violate the law, the portion of the law that deals with China specifically, it will result in felony of third degree. Our understanding of Florida statute is that a felony of third degree in Florida can result in jail time of up to 5 years. And then for buyers to knowingly violate, or for seller to have knowingly violate this law, if it's a violation under the 7 country category, it is a misdemeanor of second degree. But if for a seller to knowingly have violated this under the portion of the law dealing with China alone, it is a misdemeanor of first degree. So again, there are differences of penalty level which we should be aware of. Now, the next slide. So the law not only has significant consequences at the end of the day, but also has significant consequences during the process. By that, we mean that there are pretty large burden of administrative burdens on parties involved in transaction. For example, registration requirements, right? In Florida, as well as in other parts of the US, typically privacy regarding the ownership chain of a company or organization is very well respected. And in this, though, because of the registration requirement, even though currently we don't know the detail about how much detail will go into the registration form, but definitely will require those parties to provide more information about their ownership to the state government than otherwise previously imposed. And the second administrative burden is that going forward in real estate transactions, the buyer has to provide an affidavit. Again, we don't have the form of the affidavit yet. Perhaps it will just be a simple form to fill out. We also have to watch to see if this buyer's affidavit needs to be applied to broader transactions, not just direct real estate purchase or sale. And the third category is really this very vague but morphed idea of implied duty of due diligence, which is a very large category we have to be very careful about, because the questions we may have to answer, but we have to be careful in answering include, who is the indirect owners in a buyer? If we're the seller, who is the indirect owner of the buyer? And then the buyer's domicile country, their citizenship, their permanent residence status, and the buyer's ownership of other property. Because remember, later on when I tell you about the exemptions, one of the exemptions is that you can only own one residential property, which means you cannot already own other property in Florida. So do we now need to ask the question of what you already own? And then the next question is the property's geographical location in relationship to a military installation or critical infrastructure facility. So who is capable and able and authorized to map out the state of Florida to show us the property that's safe to be sold outside of either 5-mile or 10-mile radius of a military installation or critical infrastructure facility? And then the next question is the size of the property, because in certain categories of exemptions, the size of the property also matters, because under one exemption, you can only buy up to 2 acres. So who is able to tell us the precise size of the property to make sure we comply? And lastly, the use of the property also matters. The agricultural ban, there is virtually no exemption. And then certain exemption only applies to residential. So how do we determine the use of the property to ensure compliance again? So those are just examples of some of the questions for due diligence now we have to contend with. Now let's go to the next slide. All right. So this one Bill already mentioned, but I do wanted to highlight because the ban applies to direct and indirect ownership, because this is so important to highlight, because if it's direct ownership, then it's much easier to identify. But if it's indirect ownership, then it's so much harder to go upstream of the ownership to figure out who owns what, at what level, what's the percentage. There is a de minimis exemption. However, it doesn't really help with respect to vast number of transactions, because we know in real estate, most transactions are done through private deals instead of publicly listed securities. There is also statutorily, there is a definition for controlling interest, and I have put on the definition here. But again, the definition is not a requirement for indirect ownership to be subject to the law. So in a way, while there is that definition of controlling interest, but indirect ownership does not have to be controlled in order to be subject to the law. So it doesn't also help. Then lastly, for indirect ownership, there is also implied or actually expressed registration requirements. Again, that goes to the administrative burden and also the privacy concern here. Going quickly to the next slide. Now I wanted to talk about the exemptions from the law. So as I mentioned, if a person who otherwise falls under those categories of either 7 countries or China alone, but if they happen to be a citizen or a lawful permanent resident of the United States, then they are not subject to the ban. I know some questions I've raised about whether dual citizenship, how do you deal with that? So again, there is lack of clarity on some aspects of that. And second exemption is ownership through debt collection or probate. This exemption essentially allows a creditor through the enforcement of security interest or the collection of debts, and a successor through or by devise or descent to own real estate. But the catch of that is those owners have to divest their real estate interest within 3 years of ownership. And as to the registration requirements, the statute isn't very clear as to whether this category of ownership has to register. And the third exemption applies to individuals who hold a valid visa in the US, as long as it's not tourist only, or they have been granted asylum status. I emphasize granted the asylum status because the law does not say seeker or applicant of asylum. So there is a difference there. And the exemption applies to them also on a very limited and qualified basis, in that they can buy one residential property up to 2 acres, not within 5 miles of a military installation. On top of that, they also must register their ownership. Now, the next category of exemption is essentially existing ownership that has been acquired prior to the law taking effect as of July 1st, 2023. They can continue to own the property directly or indirectly. However, they must register with the appropriate Florida agency by December 31st, 2023. One thing to point out is that as the statute is written, at least there is no express statutory exemption for contracts that are signed before July 1st, but are set to close after that date. Hopefully there will be some rulemaking process to fix that, but as of now, based on the statute alone, there is no exemption or exception for that. Now let's move on to the next slide, please. So who are affected by this law? As we mentioned multiple times in this presentation already, the law is quite far-reaching and sweeping. It definitely affects existing real estate owners in case their structure directly or indirectly would be a violation of law as of July 1st. But if they're grandfathered in, now they have to register. It affects direct buyers going forward because they have to comply with the statute. It affects sellers and transferors of real estate in Florida. Interestingly, the criminal penalty applying only to sellers. So one may argue that perhaps a gratuitous or a donor of real estate in Florida may not be subject to the criminal penalty, but again, that's subject to the legislative amendment perhaps, or even rulemaking, or even interpretation of the law going forward. It applies to real estate investors directly or indirectly. It applies to private equity funds or other investment vehicles, both for purposes of forward-looking when they try to do a new transaction in Florida, making sure they comply with the ownership restrictions, as well as looking back at their existing structures to make sure they comply with the registration requirements. It actually affects lenders. As I mentioned, that one of the exemptions of the law applies to essentially lenders or others who acquire properties through the debt enforcement process. But what the legislature also have imposed is the forfeiture as a risk of violating the law. Therefore, all the lenders should be very careful to ensure that their collateral is not going to be subject to this forfeiture risk. Perhaps that will lead to them also wanting to know that their borrowers complying with this law. Title agents, closing agents, attorneys, and closing parties are also have to be concerned with this law to make sure they are not violating this either knowingly or unknowingly. And perhaps there are other categories of parties who should know and care about how to comply with the law. And then I may have a couple more slides. Can we go to the next, please? Some of the uncertainties and unanswered questions about this statute, I think throughout our presentation, we already mentioned a number of points, but I wanted to highlight a few more. So first of all, how do we determine whether a property is within 5 or 10 miles of a military installation or strategic infrastructure facility, especially in the category of strategic infrastructure facility, given its broad definition, it will be challenging to figure out who has the ability to map that out. And the second question we had was what documents or due diligence to conduct as a seller or a buyer or parties involved in the transaction in order to ensure their compliance. This is really a question not only for the direct parties, but perhaps for lawyers as well involved in the transaction. And then another uncertainty is the interplay with other laws. As Bill mentioned, perhaps the Fair Housing Act, if we are doing residential sales to consumers, that will come into play because Fair Housing Act prohibits any national origin-based discrimination. And potentially there could be also some interplay with our state constitution as well as our US Constitution. I also mentioned, does this law exempt donors in a charitable giving situation? Also, there are a number of unclear definitions, such as what is domicile and also what is Venezuelan regime of Nicolas Maduro. Does that mean that it only applies during his regime, therefore afterwards it wouldn't apply anyway? Some of the other challenges or uncertainties with the law is that we have heard that perhaps there may be legal challenges, meaning lawsuits. First of all, we don't know when it will be filed, and once it's filed, how long it will take to resolve. Of course, if there is a preliminary injunction in place, then that would hold off the effectiveness of the law. But short of that, even if a lawsuit is filed, it may take a long time to resolve, especially given perhaps appeals involved. And also regulatory implementation and the rulemaking process, Erin is going to talk more about that, hopefully will help us clarify some of the questions, and also the new legislative session that is coming in Florida, and which hopefully will also clarify some of the issues and maybe even see some amendments. On my slide, I put a quote from one of the newsletters I received this weekend from a trustee state attorney in Florida. They do a newsletter, I guess, on a periodic basis, and he made an interesting observation is that perhaps the law's broad scope of diligence burden it was imposing on all purchase and sale transactions to prevent what is likely a relatively small level or prohibited ownership activity, and whether less intrusive methods could have been crafted or otherwise achieve the statutory aims. But no matter what, the bottom line is the law is in place, has been signed. We need to make sure our clients and ourselves comply with that. So let me now turn it over to Erin to talk about registration and also rulemaking.
Thank you, Jen. So through Jen's presentation, there was a lot of discussion about the registration procedures involved in this. And I want to make clear, because there were a number of questions in the chat pertaining to the registration. If any of these people or entities currently own property that fits any of these definitions and that's owned prior to July 1st, and the statute says owned, and they must register with whichever appropriate agency is covered by it. So for example, the Department of Economic Opportunity, which is being renamed the Department of Commerce, those registrations related to property for military infrastructure and the China-specific provisions will go to DEO/Commerce. Florida Department of Agriculture and Consumer Services, they're handling the registrations for agricultural land and critical infrastructure provisions. So, as I said, the key date there is if it is owned prior to July 1st, 2023, the registration must occur by December 31st, 2023. And I'm pointing out as December 31st, 2023, because one of the statutes says January 1st, but 2024, but I want to be on the safe side and point out that the other provision is December 31st. So the statute particularly lays out what must be reported for each of these. But one thing to note is that at this point in time, we don't know what division of the particular agency will be the one accepting the registrations. We don't know if there's going to be fees involved. We don't know what the forms could look like. We don't know if there's other timelines involved. That'll be in part of the rulemaking, assuming it's part of the rulemaking, which I'll touch briefly later. But at this point in time, there's still a lot of unknowns there. Now, as it goes for purchases of property where the ownership transfers after July 1st, 2023, the registration has to take place within 30 days after the property is owned or acquired. Now, that is what it says in the statute. As Jen pointed out earlier, there's some ambiguity there, but within 30 days after property is owned or acquired, following July 1st, 2023, that's when those registrations must occur. Now, you want to talk about what the penalties were? Jen pointed out that failure to timely register results in a per day civil fine of $1,000. Additionally, the individual agencies that are taking the registrations, they will have lien rights with respect to those civil fines. And I wanted to point that out as well. So, moving beyond the registration portion, the statutes, each of the statutes under the law now specifically require rulemaking by the agencies that are controlling these provisions. So what does that mean? Agency rulemaking falls under Chapter 120 of the Florida Statutes, and it's a way to implement the laws. So what happens here is it specifically said that the Florida Real Estate Commission has to develop rules for the form of affidavit required for the purchases and sales. So that's Florida Real Estate Commission. DEO Commerce is going to create the rules dealing for the military infrastructure and the China-specific provisions. Department of Ag and Consumer Services, they're going to create the rules for agricultural land and the critical infrastructure provisions. And also, we're not really addressing it in this presentation, but there are certain contracting provisions for government contractors, and those rules will be implemented by Department of Management Services. So, what does rulemaking mean? It means that there's the statutory process that I brought up, where there's going to be a notice of proposed rules filed in the Florida Administrative Register. It creates a commenting period. It'll have the draft rule language involved, and there's a certain timeline and process for these rules. At this point in time, we don't know the timeline for any of the agencies for when they're going to propose rules or adopt these rules. Furthermore, we don't know right now what these rules could be. It could be as simple as just installing an administrative framework, filling out the stuff that we don't currently know, such as which division of the relevant agency is going to accept the registrations, figuring out the timelines, the filing fees, and establishing forms. Or the rules could be more substantive, but one of the issues there is that rulemaking is limited in implementing the law. The rules can't interpret the statute. So as we raised, as Jen spoke about, there's a lot of ambiguities that may not be solved in the rulemaking process. So that's something we need to note. And with that, I think I turn it over to Bill now. Thank you.
Thank you, Aaron. I want to highlight a couple of things and answer what has been a common question, and invite my co-panelists to comment on also. Critical infrastructure, as I have said, Jen and Aaron, it is a very broad-based. Many of the questions said, well, we live or someone lives close to the Port of Miami, Miami International Airport, as examples. Would that 10-mile radius cover that? Yes. The point is, it's not a question of mapping it out. That's a good thought. But one has to presume in going into effect July 1, virtually all of the coastal areas and populated areas of Florida have some coverage here, and it affects them. Because if you talk about electrical lines, you talk about transformers, you talk about gas pipelines, you're talking about items that are crisscrossing the state, are omnipresent, if you will, throughout the state. So we should go about this looking at a presumption that most populated areas are within this 10 miles of critical infrastructure. It's easy to look at the bases, the military bases, and identify those in the radius. It's much less likely, or much more difficult, I should say, to identify everything covered under the broad definition of critical infrastructure. Second point, we've been asked many questions, even before this presentation. What if we have contracts entered into now or previously for closings to occur after July 1? The fact is there is no, and Jen pointed this out, no statutory exemption for contracts that existed before July 1. And we know there are registration requirements. So there must be, at minimum, in our view, a disclosure. There should be registration occurring. There is required to be registration occurring, as Jin Liu and Aaron Dunlap have indicated in some detail. So the fact that a contract is entered into prior to the effective date of the statute does not give us any basis to avoid registration requirements and potential penalties under the statute. With that said, I'd like to turn it over to Carrie Hebring. Carrie, myself, and Aaron are lobbyists before the executive agencies and the legislature. And Carrie, I realize it's somewhat speculative, and you and I have been called upon by some clients already, and we will be called upon by others. What are the potential areas where you see clarification being made, more likely legislatively, as Aaron pointed out, than rulemaking because of its limitations that it cannot interpret the law? It's really implementing the law. But where do you see some of the areas of potential clarification or modification of this amorphous statute?
Okay, thank you, Bill. Well, the first one I would say would be the definition of controlling interest is one that needs to be looked at. Likewise, the definition of foreign principles, because as you pointed out in your opening remarks, it includes an association, an organization. There's a lot of tentacles that come out from that definition. The de minimis indirect interest ownership is also another area where I know we've had folks ask about. And so maybe that definition, is 5% the right number. A consistent affidavit between the agencies. Agriculture is going to be developing their affidavit. As Aaron mentioned, Department of Commerce will be developing theirs. And so that might be something where we want to make sure those are consistent. Definition of critical infrastructure facility. You talked about that some, but that includes things like a telecom central switching station. It includes a chemical manufacturing plant. So that list is so broad. We're going to find a lot of property that's going to be touching something that's critical infrastructure in the state. What does that do to the value of the land? So again, that's another area we want to look at. Limited residential exception. As Jen Liu mentioned, you can only buy 2 acres within 5 miles of a military base. That's an arbitrary number. Is that something that should be looked at? Is 2 acres the right number? Is that something that should be revamped? You already talked about also there's no definition for domicile. That's something that perhaps should be addressed legislatively. Indirect ownership, another area that could use some exploring. And lastly, I would say the issue you just touched on, Bill, and that would be contracts in play. So contracts that are currently, been signed, being executed, homes are being built, buildings are being built. What do we do with those to protect those interests and make sure those contracts come to fruition as first intended prior to the governor signing Senate Bill 264?
Thank you, Carrie. Just the length and number of provisions needing amendment, needing clarification, indicates really the seriousness and broad application of it. Some specific applications that we have not covered, except by reference, I want to turn to our colleague Rob Friedman. I mentioned closing agents, which is covered, and potential liability. There is the aspect of title. Several of us have mentioned the severe remedy or penalty, really, of forfeiture, civil fines becoming liens on property, all of which has a direct effect on title and the ability to convey title or mortgage title, and an impairment of the ability to do so. Rob, do you see any other, as we act as closing agents, we act as title agents regularly in all sorts of transactions, commercial, residential, improved, unimproved. How do you see this affecting some of the roles we play as far as title, closing agents, or both?
Thanks, Bill. Much appreciated. And before I reference that, I put in the chat, not in the Q&A, I put a link to the laws of Florida that has this legislation, so you can download that and take a read of it. The difficulty with aspects of title closings is that at times you don't, the closing agent and the title agent are distinct and separate obligations and duties, yet they blur. And the statute clearly says that unless there's actual knowledge by the closing agent, there is no liability if the affidavit, even if the affidavit's not obtained. But the problem is, where do you draw the line? Yes, on the title side, you may have some angles, you may have some protection, but that doesn't necessarily solve the issue in terms of who you're representing. Because a lot of times you're serving as closing agent and title agent, but you're also representing a party to the transaction. And knowledge may come into play, even suspicion may come into play. And if a transaction is deemed to be improper and there's a forfeiture, the attorney may not be able to say that they are totally clear of knowledge and may have some liability there. Plus, you have to also always ask yourself, what role am I really in? We have a number of title underwriters on this webinar today, and from having had some discussions with several of them, right now it's a bit up in the air. There's some title underwriters who are taking the position that this is not a title issue because the jacket to the title policy excludes coverage for violations of law. Other title underwriters have taken the position we need to be more proactive and perhaps put something on the Schedule B2 as an exception, similar to an OFAC type of disclosure and exception, to be able to provide better protection and knowledge. One thing that's key that we think is going to happen is you're also going to have purchase and sale contract provisions that are going to come into play that relate to all of this from a disclosure standpoint. So there's a lot of uncertainty here. I know that the Florida Land Title Association is working with the title underwriters to try to find a common ground so that the underwriters all take the same positioning with their agents. So that way we don't have differing requirements with differing underwriters, which would have a significant impact, as this law already has, on transactions. But imagine if one underwriter has a set of requirements that's different from another underwriter. You can see the potential for something to be missed, something not to be followed, and then when there's a problem, it all comes back down to the title agent and the closing agent. So there are a lot of different ramifications that we just don't know the answers to yet. Once we see what is in the affidavit, we may have better answers. We also will see where the title underwriters want to go with this. Bill, can I address one other question that keeps coming up? I had a couple of people asking the question: how does this impact rentals? The answer is the law does not deal with rentals. Now, you could see the next step after this law being of sales and ownership being extended to rentals. You could see that potential with the legislature, but it's not there now. And also, how does this involve brokers? Law doesn't speak to anything involving brokers. However, if the broker has information and knowledge, the broker has a typical duty to be able to disclose. So the broker may have to be asking questions. That's an issue that FREC is going to have to address, and that your individual brokerage agency is going to have to look at from your own internal protections. So there are a lot of different moving parts to all of this.
Rob, let me expand on some of those things. All excellent points, very practical points. Let's talk about brokers. I would not rely on the fact that one is a transaction broker under the FREC rules to say, I don't know anything, I'm not an agent. If you're a buyer agent or a seller agent, especially a seller agent, because the seller has many of the penalties and duties, I believe that the amount of knowledge that one actually has could come back in an agency perspective to that owner and their agent acting for their principal. Second, going into title, the question has arisen whether a liability under this act, because as we said, it can affect title through forfeiture, through liens being enforced, be disclaimed under the general violation of law exceptions under title policies. Perhaps. But some of us have theorized, at least, that perhaps there will need to be a separate, what we call a B2 exception, specifically dealing with compliance under this act. At the same time, we have to be very careful so as not to violate fair housing when we're dealing with residential property, which raises a whole nother question having to do with closing agents, having to do with sellers, having to do with developers. And really is, there will be an affidavit, there will be a form prescribed through rulemaking, and the question becomes, what becomes the level of due diligence to determine coverage under the act? And does that due diligence itself run potentially afoul of fair housing in the case of residential real estate? I don't have the answer to that. I'll open it to my colleagues for discussion. I'm not sure there is. But it begs the question of due diligence when we talk about closing agent, when we talk about title agent, when we talk about real estate agent representing one of the parties to the transaction. It was mentioned by Jin and others, the effect on lenders. Lenders have many loan covenants and provisions of mortgages about compliance with laws. This has a direct effect. If the security, if the real property securing the loan becomes at risk because of non-compliance, undoubtedly that would be a direct impairment of the security interest. So the lender response to this, and in terms of lender requirements, lender due diligence, covenants and loan documents, of course, has yet to be seen. And that is another area where we're looking at from a standpoint of potential legislation rulemaking. At this point, I'd like to, we'll try to answer some other questions in the remaining time, but I would like to pose that our team will be involved in representing and advising clients on the implementation of this in all the respects we've been talking about: private equity, ownership, public, private, buyers, sellers, investors, lenders, brokers, various parties involved, rulemaking for implementation and comment if there is an opportunity for substance, and potential amendment. If anyone is interested in contacting us, I invite you to contact any member of this team, and we'd be happy to have discussions whether it is worthwhile and whether we can assist you and advise you relative to how this law, in its many respects, potentially or actually affects you and the best way to comply with it and deal with it. Rob, you may have some comments in that regard.
And I just want to add, there's probably not, in a lot of cases, a one-size-fits-all answer to that. For a lot of our clients, they have differing approaches, differing structures, and to say that one answer for this client will apply to another client isn't necessarily the case. So I just encourage you to look at that and not get caught in the trap of I hear what an answer is, I'm going to apply that to my own particular circumstance and feel that you're necessarily going to be covered. You may be, but there may be wrinkles that come into play that have an impact upon you. Should we turn to some questions? I've been trying to monitor answering some of them. Let's go back to the regime of Nicolas Maduro. Several people have asked, why did they put that in there? We don't know. We don't know specifically. Oh, Bill's got something. I'll let you.
I've got the answer.
You got the answer. Never mind.
Both this administration and the prior administration, federal, basically ruled, I think by executive order, we do not recognize the regime of Nicolas Maduro as a legitimate regime. And as a result, the question of who is in, I won't say power, but who is a legitimate government in the eyes of our federal government comes into play because of these varied executive orders. Right. Drawing upon that, Governor DeSantis and his team similarly recognized that there's a question of legitimacy. But anyone associated with this the current regime of Nicolas Maduro, which really expands to all of Venezuela,
right,
and expands to all Venezuelan national held real estate in the state of Florida, as far as I'm concerned. It at least begs the question. So if one says, oh, I don't have to worry, I never worked for the government in Venezuela, and I have this property, well, you may still have to register.
Yeah,
and I can't tell you why, but
you may be limited. That's where I was going to ultimately head for these questions that are coming in as I'm looking at them on my other screen. At the end of the day, we have to read this provision until we see otherwise as anyone in Venezuela, unless you can find a way to get comfortable that this person is not within the definition of a foreign principal as a result of this. There's no other way to do it. Who's to say how that really works?
Yeah, there were 4 or 5 questions questioning the constitutionality. Mm-hmm. Undoubtedly, there are questions. I've been involved in discussions with other counsel elsewhere about whether this violates the Commerce Clause, whether it violates equal protection, of course, fair housing. We expect, as Jinlu mentioned, various lawsuits to be filed questioning or the validity and the constitutionality. But in the meantime, we've got a law that's effective in about 40 days or less. So we have to deal with it. But undoubtedly, there are reasonable questions about violation of the Commerce Clause, perhaps equal protection, and other aspects. Also, takings clause, that's come up also. Whether the state has jurisdiction, preemption, and conflict relative to matters of national security. I'm not going to go there, but those are all legitimate questions that have been raised.
Let me, and related to that, several people have asked, what about people of dual citizenship, where they are in a country, where they're a citizen of a country that is on the list, but they're also a citizen of another country that is not on the list. Anybody have any ideas of how that gets dealt with?
Well, I think the statute actually uses the language domicile, right? It actually does not use the language citizenship. So it will be interesting to see how the definition of domicile is provided,
right,
that we know how it applies to the situation. So again, it's uncertainty and unclarity.
Right. And to go on that a bit more, because all of us have raised the point that there's a lot of ambiguity in this statute. For clarification purposes, the next legislative session currently is not scheduled until January of 2024, and committee weeks for the House start in the middle of September and the Senate start in October. So if we're just going along with the regular time frame for possible clarification legislation, it's still a while away.
Right. Another question that was here. I'm just trying to find where it was. Bear with me.
Rob, there was one about protections accorded a lender or lien holder.
That's the one I was looking
secured
for.
property be forfeited. I believe Jin discussed the exemption of ownership through debt collection or probate, but that's very limited. So you take title to your security interest if you're a lender, but you have to divest the property within 3 years. So you now have potentially you foreclose on someone who's a covered foreign principal under the Act or other coverage under the Act, and you get your certificate of title. You now have a nice REO that you have a 3-year clock going on divestiture of it. And by the way, it's expected. I'm not an appraiser at all, but this will have some effects on various submarkets as far as potential valuations, unless it is more limited, less ambiguous, because some pointed out, does this mean that every Venezuelan person who buys a condo on Brickell Avenue or in Doral is covered? Well, potentially, if they're domiciled there and this is their second, third, or investment home, yes.
Can I go back to that question about forfeiture?
Yes.
I think there was a question raised about basically what about existing lien rights, right? So the statute is written in several parts when it mentions forfeiture. It says, if the court finds that the subject land or any portion of is owned or held in violation of the law, the court must enter a final judgment of forfeiture, vesting title to the state. Okay, subject only to the rights and interests of bona fide lien holders, and such a final judgment relates back to the date of the list pendant. So basically, the forfeiture will result in the state owning the property subject to existing bona fide lien holders' rights. And also, the statute continues to say, in that event, the applicable government agency of the state may sell the property subject to the final judgment of forfeiture, and the proceeds from the sale must first be applied to pay off the lien holders of the land, followed by the payment of any outstanding fines assessed under the statute, after which the department must be reimbursed all costs involved in the forfeiture process. And then lastly, the remaining proceeds will actually be going to pay the property owner. But again, there is no guarantee that the sale will be at the right time to have sufficiency of proceeds to either pay off the lien holder or even pay sufficient consideration to the property owner. Lastly, also to mention that forfeiture process, if the state determines that the ownership of the land constitutes a clear and present danger to the state actually can seek ex parte order to seize the property. So that's a pretty, again, very significantly, basically diminishing the rights in the procedural front to allow the state to do this on an ex parte basis.
Yep. Another question got asked about the lien that the department can place for failure to have registered. And when does the lien, how does the lien work? Does it backdate to the date when the payment should have been made or the registration should have made? Does it come forward only when the lien is recorded? Statute doesn't speak to it. It's totally silent as to this, as to when the lien really has effect and what is covered under the lien. That's going to be subject of rulemaking, presumably. We just don't know yet. Statute's very generic in that regard. Here's an interesting question that relates to Florida homestead. Someone asked, if the husband is a U.S. citizen and the wife is a Chinese citizen and they're under contract to buy a home, if the contract's amended to remove the wife from the purchase so the deed's only to the U.S. citizen, are they safe? First off, let's hit that. What do you all think about that? Let me add the next part of it. Let's say it's homestead property. If it's homestead property, the wife is not on the deed, the husband is, but the wife has has homestead rights. Is this covered? I think yes. What do you all think?
And the phrasing of indirect in the statute, I think that's the trigger.
Yep.
Right.
Okay.
I agree. This coverage.
Someone asked, how does this coincide with CFIUS? Did we already cover that? We may have. Did we hit that, Bill?
Well, we hit it because it does CFIUS. You're going to get into a question of preemption or conflict, especially in publicly traded. If you comply with CFIUS, it applies to you. This is a typical REIT question. It's even a private equity through private placement question. If you're an investment advisor under the 40 Act, right now we're looking at that because we think the statute is insufficient in its de minimis exemptions. Seemingly, there's an intent to cover registered securities and security advisors, registered advisors, but it's limited to the 5% rule under the de minimis.
Right.
It doesn't clearly deal with those who manage, and there are many management, U.S.-held, U.S.-controlled management companies, but somewhere in the investment organizational structure, there are those domiciled in one or more of these nations that are covered. And we find, therefore, the de minimis rules insufficient to protect those companies, and they're not protected. It's been concluded under CFIUS because this is more specific and has a different application than CFIUS does, although one may make the preemption argument in all the other challenges we've mentioned to the Act.
Yeah, I think Bill is exactly right because as he mentioned that there are already, I think, some rumors that perhaps lawsuits will be filed, and the basis of the lawsuit could include, violation of the 14th Amendment, equal protection, and also possible violation of Fair Housing Act, and possible violation of Interstate Commerce Clause, and possible federal preemption based on CFIUS. And I think there is also federal law governing agricultural land. So that also raises, again, going to the theme that there is quite a number of uncertainties as well as ambiguities in the statute that we have to contend with.
Let me add one follow-up going back to that question related to homestead. It was correctly stated that someone said, couldn't the wife of Chinese citizenship potentially utilize the exemption for one residential property? I think the answer is probably yes.
Yes.
So that is a good clarification. What about pre-construction contracts that won't be delivered for 2 or 3 years but are signed now? What do you all say to that?
I don't think there is a clear statutory exemption for that. That basically falls under the same category of contract signed before July 1st,
Right.
but they don't obtain actual ownership until after July 1st.
Right.
Correct.
Okay. We'll hit 1 or 2 more questions. Just as a reminder to everybody, we will email out the slides and we'll also email out a link to this recording. It'll also be posted on the Carlton Fields website as well, perhaps later today or sometime tomorrow. Let's hit 1 or 2 other ones real quickly. Let's see here. How does this work with a trust ownership?
You would look at the beneficial owner of the property. If beneficiaries, even though they may not have any management or direction that is given to the trustee, if beneficial ownership is in a domiciliary of one of these nations, the argument could be made that that falls within the indirect ownership. Do you agree, Jen?
Mm-hmm.
Yeah, I agree, because again, it's indirect ownership that gets everybody.
I think we've hit pretty much all the questions. There are going to certainly be addenda that are going to come through, I would expect, from the Florida Association of Realtors that are going to address this over time. It's just too early. And we're still too early in the process, but we wanted to make sure we gave you all feedback and an understanding of the concepts that are involved so you can be on the lookout for it. But I think we've hit pretty much all the questions at this point.
Well, Jen, do you want to wrap it up for everyone?
Yes, absolutely. So again, we received a very large number of responses who are interested in today's program. So we appreciate your interest. We appreciate your attention to this very important law that has a pretty big impact in our daily practice. So if you know of someone who missed today's live program, please do check back. We will be emailing you a link to our recording and the slides. Also, you can always go to our Carlton Fields website for additional information. We wanted to stress that this is a program for educational purposes. It's not tailored legal advice. So for you to specifically comply with this law, we encourage you and recommend you seek legal advice from attorneys. And lastly, I do wanted to highlight that Carlton Fields Development Industry Group will continue to put on additional community and development programs that try to tackle emerging issues and other topics of interest to our development and investment community. So please stay tuned on that. Again, thank you, and hope you all have a nice afternoon.
Thank you, everyone.
Thank you.
Thank you.
Thank you.